Hello and welcome to our training, an orientation to the care process. You may be new to care. You may be on a county behavioral health team or working with a public defender for office or just interested in the care process in general. And this training will provide an overview of what to expect, point you to some additional resources. I'm going to be joined by the main presenter today, Leela Kapoor. Leela is our mental health law lead, and she's an attorney with over 30 years of public service representing Los Angeles and the city of Los Angeles, and her experience as counsel for the county's departments of health and mental health. So we're really pleased to be joined by her today to help us walk through the care process. Let's take a look at what we'll be covering in today's training. So first, we'll provide a high-level overview of care, what it is, what the goals are, and then we'll introduce some of the roles that will be involved in the care process, and then we'll walk through that care process and what it will look like. Just to emphasize, Care Act is more about a process. It's about connecting individuals to services and support. But the care process is designed to help connect them to that. So we'll be talking today about what that looks like. So some learning objectives. Our objectives for today is that you will better have an ability to distinguish the key roles within the care process and be able to describe the overall process, including the petition and the referral, engagement, the court process and service connection, and then service delivery. So we're going to go ahead and turn to first that overview, like we talked about. So Leela, what stands in your mind as the key overview of what care is and what the goals are?
Thank you, Patricia. Let's start with just looking at kind of the CARE Act at a glance. And it's important to remember that the CARE Act creates a new pathway to deliver behavioral health and substance use disorder services to those individuals who have really complex behavioral health conditions. It is a civil court process, so it's important to remember that there is a court process involved, and that's all set forth in the CARE Act. But what we're going to talk through today is we're going to talk through the paths into care, and there are several of them. And we're going to talk about who can initiate the care process and who's eligible for care. So that's kind of the beginning of the process. And then we're going to work through the actual steps of the process and explain to you what each of those steps is intended to do and what the expectations are for each of those steps. And we'll talk about how people can get out of the process and what happens when the process is completed. Because as Patricia mentioned, care is really meant to connect individuals to services so that they can be stabilized and they can work towards recovery in the community before they need more intensive intervention. So it's very important that there be engagement throughout the process and that the help continue even as the process ends.
Thanks, Leela. So why don't you talk us through about the how care can help individuals?
Yeah, so care really does take on a multidisciplinary approach, very much what people would call a wraparound approach. And it is very focused on trauma-informed outreach and engagement. And what that means is that you're looking to engage individuals where they are in the community, where they are in their particular situation in life, and work towards building a trusting and relationship with them so that they will participate in their treatment and they will access the services and supports that are available to them in the care process. This slide shows you some of the services and supports that are offered through care. And just to highlight a couple of them, one very important one is housing. Stability and recovery in the community is really dependent upon having a stable living situation. Another aspect of care are supporters and peer support, and we'll discuss that as we go forward in this presentation. Medication may be something that is offered to the individual. And this is all wrapped up together. The way that it's presented in care is through either a care agreement or a care plan, and that is part of the court process. And we'll talk about that in great detail as we go forward. The one thing that you really should keep in mind throughout this discussion is care is really meant to be a less restrictive alternative to some of the other options that are sometimes afforded to individuals with mental health issues, one of which, for instance, is conservatorship. or hospitalization. Care is really aimed at trying to address those individuals' needs and provide them supports and services before they get to the point that they need more intensive treatment.
Thanks, Leela. And if you would like to look at the full notes, spend time more on the the topic or see more information, we always have the talking points, all the resources linked in the training PowerPoint. So if you want to pause, you can go and look that up, have it in front of you, and engage. Click on those resources. So Leela, I know in the third section of this training, we'll be walking through the care process, but give us a high-level overview.
Okay, thank you, Patricia. This slide is the care process, and I know that there's a lot of information on this slide, and don't worry, because we are going to go through the steps that are set forth on the slide in detail, one by one, to help you to understand what the process is and what the expectations of everybody in the process are. But very quickly, just as an overview, the civil court process starts with the filing of a petition, and we'll discuss who's eligible to file petitions and what those petitions look like going forward. And there's an engagement stage. Engagement is extremely important. It's critical to know that care is centered on the concept that there is engagement throughout the process. So while there's a court process going on, county behavioral health is consistently and constantly attempting to engage the individual in services throughout that process. We'll talk about the court process itself, and then we'll talk about service delivery and what happens after the process is completed, again, to assure that there's that continuity of care after the individual leaves the care process.
Thanks, Leela. So before we move on to the next section and talk about the roles in care, just taking a step back, can you describe how the care process can be used as an upstream intervention to reduce hospitalizations, incarcerations, and conservatorships?
Yeah, Patricia, as we talked about already, care is really meant to avoid hospitalizations, incarceration, conservatorship, those more intensive treatment or situations that individuals sometimes find themselves in. And the way it does that is it looks to engage the individual when they're in the community, when they're in a position that they could use supports and services to stabilize and work towards recovery. And they really are trying to, the program really is meant to try to prevent escalation of the individual situation so that they don't need those more intensive treatments. Care provides a less restrictive alternative to conservatorship. It empowers the respondents to participate in their recovery plans, and hopefully that will allow them to be more successful in those recovery plans. And it really fosters autonomy and engagement with the respondent in a less restrictive environment. One thing to keep in mind is what care offers is housing alternatives and housing support. And housing is critical in stabilizing an individual and allowing them to recover in the community. So that's a really important part of care. And we'll talk about care agreements and care plans and what role they play in assuring that that individuals are connected to the services and supports they need in order to stabilize and recover.
Thanks, Leila. So now let's turn to a discussion about roles within the CARE Act. And let's go ahead and look at what some of those are, and we will go into more detail. So these are the primary roles. And this may look differently for each respondent and the individuals that are performing these roles, but this is overall what it will look like. So let's turn to first, you've mentioned the word respondent, and talk to us about this individual, Leela.
Yeah, so a respondent is a legal term, so you're going to hear it. I've already used it several times. You're going to hear it throughout this presentation, and you'll hear it in the court and in court documents if you are involved in the care process. But a respondent is the individual that is the subject of the petition that's filed in court. And the purpose is to try to connect that individual to services and supports, again, to allow them to stabilize and recover in the community. In order to be eligible for care, an individual must be an adult, so he or she must be 18 years or older. And they must have a diagnosis of schizophrenia spectrum or other psychotic disorders. They must also have severe and persistent symptoms which interfere with their daily functioning. They are not stabilized in ongoing voluntary treatment, and they are either unlikely to survive safely or independently in the community and their condition is deteriorating, or they need the services and supports to prevent further deterioration. It must be that the participation in care is the least restrictive alternative for them, and that they will likely benefit from the care process. So those are the eligibility criteria, and you'll hear that term as well as you go through the process. But those are the eligibility criteria for an individual to participate in care. And later on, we're going to introduce you to Michael, because Michael's going to help us walk through the care process step by step so you can see how it's applied to an actual case study.
Thanks,
We
Leila.
then go on to the petitioner. The petitioner is, so the statute sets forth who can file a petition in care court. And this slide shows you the list. This list comes directly from the statute. I'm just going to highlight a couple of them. It's important to know that family members, parents, spouses, siblings, children, or grandparents can file a petition on behalf of their family member. A roommate or housemate can file a petition if they have enough information about the individual's behavioral health situation. The respondent himself can file a petition, and that's interesting because that would be, for example, if the respondent thought that by participating in care, they could get more access to the services they need, they may choose to file a petition on their own behalf. And then there are a list of behavioral health professionals and facilities involved in the individual's treatment that can file a petition on behalf of the individual, and first responders, and that includes law enforcement, emergency medical personnel, and even homeless outreach workers who've had repeated interactions with the respondent and feel that they have enough information on which to file a petition. So it's important, if you're interested in filing a petition or if you want to know more about the petition process itself, really encourage you to look at the resources that we have online. And Patricia, maybe you can tell them a little bit more where they can find those resources.
Yeah, so they are linked here in the training materials. You can go ahead and click on that CARE Act resources for petitioners. That will take you to a landing page with information about how to complete the forms, recommendations on what to include. And then it has specific guidance if you're different petitioner types, gives you some information that would be specific to you as maybe a first responder or as a lay individual, a family member. So if you go to that landing page, it'll point you towards specific resources and help you walk through those petitioning forms in more detail. So Leila, now let's go ahead and talk about some of those judicial and legal roles. You've mentioned this is a civil court process. What are the different legal roles that come into play, and what should people know about them?
So as it is a civil court process, the legal roles are common to all court processes. For example, with CARE, respondent is represented by counsel. That counsel is court appointed, regardless of the individual's ability to pay. So all respondents are entitled to court appointed counsel. And the role of that counsel, much like they would with any client, is to represent the respondent's interests and rights throughout the court process. The respondent's counsel is appointed by the court very early on in the process, as soon as there is an initial determination that the respondent is eligible for care. So the respondent will have counsel with them throughout the process. The other role that is played by, in a legal role that is involved in the care is obviously the judicial officer. As with all cases, the judicial officer is to be a neutral arbiter. But the statute really sets up the process to be as informal and non-adversarial as possible. And so the judges are very much encouraged to keep the process as informal as possible. And the judge's role, in addition to guiding and overseeing the process itself and making the determinations that they are required to make under the statute, is to hold everybody responsible. And when we say responsible or accountable, we don't mean just the respondent. Just the court isn't there just to provide a black robe effect to encourage adherence by the respondent to continue with their services and supports, but they also are there to hold the service providers accountable. The county and other agencies that are ordered to or agree to provide services are held accountable under the act to actually offer those services to the respondent. So the judge plays some very critical roles in working towards making the process as effective as possible in getting the individual connected with services. So let's move to another role in the process, and this is the volunteer supporter. The CARE Act allows for any respondent to choose an individual to be their supporter throughout the process. It's not required, but it's something that every respondent has the option to do. And what a volunteer supporter does is, first of all, it's an adult who's chosen by the respondent, again, to support them through the process and really work to promote the respondent's preferences and choices and allow them the autonomy and the decision-making authority that they should have over their own life and their life decisions. They're really there, the supporter is really there to assure that the individual's preferences and values and beliefs are heard and respected, and to help the respondent understand the care process and the expectations that the care process has for them. They'll include helping to develop the care agreement and the care plan, graduation plan, psychiatric advance directives, and we're going to discuss all of those elements of the process going forward. But the volunteer supporter really is there just to assist the respondent and ensure that their preferences are heard and that their values and beliefs are respected.
So now let's turn to the County Behavioral Health Agency. Talk to us about the role of the County BH agency, and maybe talk through some examples of what those providers could look like.
Yeah, so county behavioral health plays many different roles in the process, and we're going to discuss all of those, but just kind of to give you an overall view, county behavioral health is an eligible petitioner, so they can file petitions on behalf of individuals if they believe that individual is eligible and will benefit from care. But they are also responsible for providing the services and supports and working with the individual, the respondent, to develop either a care agreement or a care plan that lists the services and supports most appropriate for that individual, and to work to assure that those services and supports are actually offered to the individual. So the county behavioral health agencies, whether they do it through their own county agency or they contract with a provider to take on these roles, it's critical throughout the entire care process, starting with engagement and assessment of the individual early on and all the way through graduation and the continuation of services after the process is completed. Different counties are staffing their teams differently depending upon their resources and how they are structured. This slide sets forth some examples of behavioral health team members or potential members. Obviously, behavioral health professionals of various classifications, including psychiatrists and clinical social workers. Some counties are using program managers and team leaders to oversee the programs. And some counties are using peer specialists, which it has proven to be very effective, people with lived experience that can assist in framing the process and providing their insights to the county team. So again, every county is going to have to determine how it wants to staff its care team, but each county is doing it a little different, and some of them are having great success. So it might suggest that if you are a county behavioral health agency, you reach out to some of your fellow counties and get ideas as to how they're staffing their teams.
And, we talked about earlier about care is more than a court process. It's about connecting individuals to services, supports, and housing. So can you talk to us about the role of housing and community support providers?
So again, the housing and community support providers are probably the most critical portion of the care process, because without the services and supports, the goals of care cannot be met. we focus a lot on housing because it is so critical. And we mentioned on this slide that housing comes in different forms. There's permanent supportive housing, there's interim transitional housing, which is bridge housing, affordable housing models, community-based housing. So different counties have different availability and accessibility to housing, but that is a very important part of the care process and the care and reaching the care goals. Would mention that care participants are prioritized for behavioral health bridge housing. So the care statute specifically prioritizes them to receive that housing if it is available in their county.
Thank you. So, we just went over the roles, and just to recap, the different roles you see on the screen are the main categories. Each team will look a little bit different depending on the resources of the county and the needs of the participant. But the goal is that all of these different participants really work together, including the respondent, to develop a care agreement or care plan that will help support the individual's autonomy. So we talked an overall introduction. We've just talked about the different roles. Now let's go into that step-by-step process of what a paths through care might look like. And Leela mentioned earlier a case example, Michael. Let's take a look at Michael and consider what his path through care might look like. So Leela, do you want to give us a little bit of background about Michael and what his current functioning is like?
Sure. So Michael is 43 years old. He was diagnosed with schizoaffective disorder at 18, and he left his house soon after receiving that diagnosis. He has become increasingly distrustful of his parents and has a history of psychiatric hospitalizations. He's had at least 2 hospitalizations in the last 3 years. And he mostly seems to live in encampments near his home. So that's kind of his situation and his background. Currently, what his parents have observed is he appears internally preoccupied. He's lost considerable weight, and he seems to be sleeping a lot more, often sleeping through the day. He has been assaulted on a couple of occasions while in the encampment. He's using methamphetamines. And he really has distanced himself and seems to be declining help from his parents and from the homeless outreach team that has attempted to work with him. So that's Michael. We would suggest to keep Michael in mind as we go forward through the steps of the process, both as to his potential eligibility for care and how his journey through care may unfold, given his needs and his situation.
So given Michael, let's think through what some of the options are and what CARE Act can offer someone like Michael. So Leela, talk to us about some of the options that we could use to provide services for Michael.
So Michael's parents have spoken to a lot of individuals. They've spoken to advocates, mental health professionals, social workers, and they realize that Michael is really starting to fall through the cracks, and that his situation may be deteriorating. So, they've considered different options. They've considered whether it would be appropriate to try to get him placed on a 5150 hold or have a conservator appointed for him. And in looking at that, they realize that he may not qualify for either of those things. He is sleeping outside, but he's using a sleeping bag and he is eating. He's using local soup kitchens to get food and other sources. He does not appear suicidal, and he does not appear to be a danger to others or express an intent to hurt anyone. So it's possible or very likely that Michael wouldn't qualify for a 5150 or in need of a conservatorship. What about AOT services? Well, he may qualify for AOT, which is assisted outpatient treatment. He has been hospitalized in the past 3 years, which is an eligibility criteria for AOT. His behavior has really not been violent. It might be intimidating at times, but he really has not acted out violently towards himself or towards others. So another approach, and this is the one that concerns his parents the most, is that you could wait and see. While he's marginally functional now, it does appear that he is deteriorating. He might be responding to internal voices. He is less able to protect himself as he's been assaulted a couple times in the encampment. He's losing weight. He's sleeping more. He's not eating as much. And his parents are very concerned that his situation is deteriorating to the point that he is going to actually need those more intensive interventions, such as conservatorship or 5150. So they look at all this and they say maybe CARE Act is the right alternative for Michael so that he can get the services and supports that he needs to prevent further deterioration of his illness. So with that in mind, his parents decide that maybe they should file a petition on behalf of their son in the CARE court.
So let's take a look at what that process might look like then. So, we introduced you to this overall process and at the very beginning, and now we're going to walk through the different steps briefly. Keep in mind that there is more information about each of these steps in the notes, and we link to trainings that will help you understand each of these points in further detail. But our goal today is to give you a high-level understanding of what this process would look like. So let's start off with that first step, which would be the referral and petition part of the CARE process. So Leela, tell us a little bit more about referrals.
Okay, so let's just start first with the concept that the process begins with a petition being filed in the court, and that initiates the process. That petition can come through directly, for instance, County Behavioral Health Agency or Michael's parents, for example, could just file the petition in the court. That petition sometimes comes out of a referral. And so I'm going to talk a little bit about the referral paths that are provided for in the statute. The CARE Act provides that an LPS designated facility that is treating an individual under an involuntary hold can make a referral to the County Behavioral Health Agency, and the County Behavioral Health Agency is required by the statute to clinically assess that individual and determine whether that eligible individual is or may be eligible for care. And if the County Behavioral Health Agency believes the individual is or may be eligible for care, within 14 business days, the BH agency is to file a petition in CARE court on behalf of that individual. So that's one referral. A referral can also come out of an AOT court if the court believes that CARE is another option, appropriate option for an individual. That court can refer that individual to CARE. The referral is made by the court, but the petition is actually filed by the County Behavioral Health Agency. So again, behavioral health would assess the individual, and if they believe that the individual may qualify for care, they would file a petition in the CARE court. An individual who has been deemed incompetent to stand trial can also be referred by the criminal court to CARE. In that instance, again, the court makes the referral. For an individual that was charged with a misdemeanor, it's slightly different than an individual that was charged with a felony. With a misdemeanor incompetent to stand trial, sometimes you'll hear the acronym MIST. With a MIST defendant, the County Behavioral Health Agency is specified in the statute as being the petitioner. So again, the referral would be made by the court, and the BH agency would file a petition with the CARE court if they believe the individual is eligible for care. With a felony incompetent to stand trial, the acronym is FIST, and those referrals, again, are made by the criminal court. The statute does not specify who the petitioner is. Most likely it is going to turn out to be the County Behavioral Health Agency, but the court and the county and the other judicial partners are going to have to work through that process and define how the petition would actually be filed. And finally, and very importantly, the CARE Act allows for conservatorship courts, so LPS conservatorship courts, to make a referral to CARE. And in that case, the conservator, if one has already been appointed, or the potential conservator, is to file the petition in CARE after the court makes the referral. So those are the referral paths that are set forth in the statute. It's very important to understand, though, that there's nothing that precludes county behavioral health agencies from establishing their own referral pathways that aren't set forth in statute. For instance, to allow for system partners such as law enforcement or first responders to file referrals or submit referrals to county BH agency for them to follow up on, or maybe family members or other community members or other providers in the community, allowing for the county to accept those referrals and then determine whether a petition should be filed. That's at the discretion of the county, but a lot of counties are doing that and finding that to be a very effective way to get individuals into care.
Thank you, Leila. So let's take a look at the next step, which would be filing of a petition packet. So regardless of whether there is a referral or not, a petition would need to be filed with the court. And we mentioned earlier, there are a number of resources for petitioners to understand what the role is of the petition and what they need to include in that. But these are statewide forms created by the Judicial Council, and they help the court make a determination if the individual is eligible for receiving services through care, and the eligibility requirements included on the petition will help the court make that determination if they meet or may meet those eligibility criteria. So let's take a look at the next point in the process after when that petition is filed. So Leila, talk to us about who can file the petition again.
So we've already mentioned that the statute sets forth numerous individuals and agencies who are eligible to file petitions. Just to mention again a couple of them now, we're seeing a lot of petitions throughout the state being filed by family members. But in addition to family members, first responders who have had repeated contact with the respondent can file a petition. The director of county behavioral health agency or his or her designee can file a petition. Public guardian or conservator, directors of certain public service agencies, mental health professionals who have been involved in the individual's treatment, and facilities where an individual has been hospitalized or treated for behavioral health issues. You have to understand that each person who is eligible to file a petition can bring a unique perspective and approach when filing the petition. Petitioners with a clinical background will have the ability to document clinical factors that could help determine eligibility, such as a qualifying diagnosis, the impact of the individual's illness on their daily living, their clinical stability, factors that would help the judge determine whether or not the individual is eligible for care. First responders and other justice system partners may have insight through their experience and interactions with the individual, including whether they've been hospitalized previously and for psychiatric purposes, whether the individual has the ability to survive in the community, whether they are deteriorating, their condition is deteriorating. And then family members often have a lot of information on the individual's historical diagnosis and their behavioral health history that they can present to the court as indication that the individual does and qualify and is eligible for care. So everybody brings their own perspective, and it's important to note that when filling out the petition, you should put in as much information as you can to give the judge the ability to assess whether the individual is eligible for care or may be eligible for care.
So Leila, let's talk a little bit more about who could potentially file a petition in Michael's case. So what about Michael's cousin who lives in a neighboring state, but is supportive of the parents and who's been a lifelong friend to Michael?
So Patricia, cousins are not one of the eligible family members. I don't know if you meant to do
Exactly.
that.
So although out-of-state relatives can file a petition,
If they're
cousins,
if they're like grandparents. I
right?
mean, I'm pretty sure I'm right in saying it's children, parents, grandparents.
Mhm.
I don't think cousins qualify.
Right. So what about the police officer who has repeatedly responded to the soup kitchen when Michael's become disruptive or when he's been assaulted?
So if the police officer feels that he has enough information about Michael's behavioral health history or behavioral health condition, he can certainly file a petition. But this might also be a great opportunity for the law enforcement to collaborate with county behavioral health, um, put make county behavioral health aware of Michael if they're not already, provide behavioral health the police officers observations of Michael and interactions with Michael, and let behavioral health do an assessment of Michael and determine whether they believe a petition should be filed and how the law enforcement and county behavioral health can collaborate to get that petition filed.
So another individual that could be a potential petitioner is the case manager for the homeless outreach team who has tried to engage Michael in treatment. And he would, as a case manager, they could be a petitioner within the first responder category as a member of the homeless outreach team. So
Yeah.
just a few ideas of different people, and then like Leela mentioned, how they could partner with county behavioral health through one of those referral pathways. So let's take a look at what happens next. So Leela, once the petition is filed, there's a Basha determination. Talk to us about what that means and what happens during that stage.
So what the court's going to be looking for when they make when they do the initial review of the petition, is they're going to be looking at whether or not Michael's diagnosis is a qualifying diagnosis in the schizophrenia spectrum or other psychotic disorder class. Does he appear likely to be at risk for not surviving safely in the community? Is his condition deteriorating? And would care be the least restrictive alternative? So again, what the court is looking for is on a very initial level as to whether or not he meets the criteria that we've discussed earlier in this presentation. Now, if the county behavioral health agency was the original petitioner and the court doesn't feel that it needs any additional information, that the petition was complete enough, what that will happen then is the court will set the petition for its first hearing, which is called an initial appearance. However, if the original petitioner was not the county, so in our case, Michael's parents filed the petition, because there was a non-county BH petition, the court will order the county behavioral health agency to conduct an investigation and file a report with the court. And so at this point, county behavioral health becomes involved, and they are to go out and engage Michael and assess Michael. And they're also, this is the first opportunity that the county behavioral health will have to provide notice to Michael of the pending court process.
And then, Leela, you mentioned, so this is the county investigative report. So if county behavioral health was not the original petitioner, the court may ask them to complete this investigative report to check, engage with Michael, document some specific information. You also mentioned if county behavioral health was the initial petitioner, the court may ask for supplemental information. Any additional information on that?
So the court will look at the county petition. And again, if they feel that there is additional information that would be helpful for the court to make its determination as to Michael's eligibility or to the respondent's eligibility, the court would ask the county behavioral health to kind of fill in those blanks. And the order may be specific. It may say I need additional information on on his diagnosis. I need additional information on the efforts that were made to voluntarily engage Michael. I need to know more about how you reached the conclusions or the recommendations you, county behavioral health, may have reached. Or it may be that they just issue an order asking for additional information, which is a little bit more generic. But either way, County Behavioral Health would be filing supplemental information with the court so that the court has all the information it needs in front of it to make the determination it needs to make. Again, if the petition was filed by somebody other than County Behavioral Health, such as in Michael's case where his parents filed the petition, the court will always order County Behavioral Health to file a report. You might hear the word investigative report. That's what this report is sometimes called. And the purpose of the investigative report, again, is to provide the court with additional information. The report should address whether or not the behavioral health agency believes that Michael meets or may meet the criteria for care, so providing their opinion to the court. And it should also include any outcome of efforts made to voluntarily engage Michael, because again, it is intended that behavioral health continually work to engage Michael in services. And if that engagement is successful, it's possible that the case would be dismissed at this point because the court would determine that the process is not necessary because Michael is successfully engaged in services. And then finally, the report should include behavioral health conclusions and recommendations as to the respondent's ability to voluntarily engage in services, again, to allow the court to know whether or not the court process is necessary or that Michael is successfully engaging and voluntarily engaging in services.
Thanks. So let's move forward. Let's assume the court has or the county has made this report, was not able to voluntarily engage Michael in services initially, but the court has made that determination that to move forward. They've reviewed the report and they want to move forward. So for the purposes of our flow, let's consider that Michael is found to be at least initially eligible and he's declined to engage voluntarily in services. At that point, he will move into that court process and connection to services. And this is also when Michael will have the opportunity to select a supporter, which we mentioned one of those roles. And let's say he selects Sarah, his mother, as his volunteer supporter. So now we're going to focus on the court process and keep in mind that Sarah, is his volunteer supporter, wouldn't be responsible for tracking these steps but it could be helpful for Sarah as his supporter to understand what's happening so that she can help prepare the respondent and clarify how they might be involved beforehand. So, we've gone with Michael up until this point. Now, Leela, walk us through what would happen in that initial appearance.
So the initial appearance is the first time that the parties appear in court. Counsel for the respondent will have been appointed prior to this appearance, and counsel will let the respondent know that they have the right to a supporter. So if Michael hasn't already chosen a supporter, if he hasn't already selected, for instance, his mother, he would be told at this point that he has the right to do that. A supporter can be selected by the respondent at any time through the process, so this would not be his last opportunity to do so. The respondent can choose to be at the court hearing, or if they don't want to be there, they can allow for their attorney to appear for them. County Behavioral Health at this point will be substituted in as the petitioner if the petition was filed by another individual. So what that means is at this point in time, County Behavioral Health becomes a petitioner and Michael's parents are no longer the petitioners. So County Behavioral Health carries all the responsibilities and carries the role of the petitioner going forward. The hearing on the merits is next. Keep in mind, though, in some instances, the hearing on the merits will be combined with the initial appearance, so there would be one hearing as opposed to two. That's only if the parties in the court agree to combine those two hearings. At the hearing on the merits, the court will determine if the respondent, so if Michael meets the care eligibility. And if so, the court's going to order the County Behavioral Health to work with the respondent in conjunction with respondent's counsel and the volunteer supporter, if one has been selected, to engage in treatment and to develop a care agreement. So the hearing on the merits will require a clear and convincing evidence standard to determine whether Michael meets the CARE Act criteria. This is a more stringent criteria than was done at the prima facie phase, where there was only needed to be a finding that Michael meets or may meet the criteria. So this is when the court makes a real determination that Michael is eligible for care. And we're going to talk a little bit about what the care agreement entails, I think, going forward. So maybe we can move to the next slide. So the care agreement, as we said at the hearing on the merits, the court's going to order the parties to engage in discussion to develop a care agreement. All the parties are involved, the respondent, their attorney, county behavioral health, and again, a supporter if one has been selected. And the purpose of the care agreement is for the parties to determine and agree upon the range of services and supports that would benefit Michael. What would he benefit from as far as his services and supports to get him stabilized and on the road to recovery? And what services and supports can the county actually provide? So it's an agreement between the parties is what would be most helpful and beneficial to Michael, and what services are actually accessible.
So then the parties were developing that care agreement. Talk to us about the role of the case management hearing.
So the parties will work towards a care agreement, and per the statute, they have 14 days unless they ask for additional time from the court to develop that agreement. And at that point, a case management hearing is held. And the purpose of that is to determine whether the parties have agreed to a care agreement. And if they have or if they're likely to do so, then the care agreement will be finalized. The court will look at it. If the court wants to suggest changes, they'll discuss changes. And eventually, if everybody's in agreement, the court will approve the care agreement and will set the matter for a progress hearing in 60 days. So that what this means is that the parties have agreed to an agreement, and the services and supports that are provided for in that agreement should be provided or offered to Michael. And in 60 days, the court's going to come back and look at the progress of Michael's progress in accessing those services and supports, and hold the county accountable to assure that those services are being offered to Michael. The statute requires that there be one progress hearing in 60 days, but the court does have the discretion to hold additional hearings if it chooses. If a care agreement is not reached, for instance, Michael does not agree with the care agreement, he doesn't want to take medication, he's not comfortable living outside. He is comfortable living outside in a homeless encampment, he doesn't want housing. At that point, the court will order county behavioral health through a licensed behavioral health professional to conduct a clinical evaluation, which we'll discuss on the next slide. So a clinical evaluation, again, is done if the parties weren't able to reach a care agreement. County behavioral health will evaluate the respondent and will report back to the court on the respondent's diagnosis, their ability to give informed consent to medication, and any other additional information that they believe would benefit the court's decisions going forward. The court will review the evaluation, and at that point, at the clinical evaluation hearing, will confirm Michael's eligibility and will order the parties to develop a care plan.
So let's take a look at what that care plan will look like.
So a care plan is very much like a care agreement. The difference being, again, the purpose of which is to set forth the services and supports that county behavioral health believes are would be helpful and beneficial to Michael. So it identifies a range of services and supports for the respondent. And the respondent, their attorney, county behavioral health, and the supporter ideally will work together to develop the care plan and agree upon a care plan. However, if they can't reach agreement on a care plan, then County Behavioral Health can submit a proposed plan to the court, and the respondent can submit their own proposed plan to the court. The court will then, at the care plan review hearing, will then review the proposals that it has received from the parties as to a plan, will select those elements that the court believes are the most appropriate for Michael. The court may ask to hear from the parties or from the clinicians who participate in the development of the plan. So Michael will have a chance to present any evidence he wants or any testimony he wants as far as the appropriateness of the plan. And at that point, the judge will develop a plan based on the elements that he feels are most appropriate from the proposals, and he will issue an order that the care plan be effectuated.
Thanks, Leela. So the next step after that care plan review hearing, and it's where it's ordered by the court. So once the care plan is ordered for 1 year, the status review hearings will take place no less often than every 60 days. So roughly every 60 days, but they can happen more often if people want to get together, review the plan, check in with Michael. So the status hearings are not just for the support people and treatment providers to report on how Michael's doing. It's also for Michael to say if there are services in his care plan that he's not getting, or to ask the court to enforce those services. So they will continue throughout this year to have these status review hearings. This is also where both parties can make amendments to the care plan and adjust those services to support recovery. So Leela, Michael's going through receiving services. We're approaching 1 year. So what happens at the 1 year status review hearing? What are the different paths that Michael can take from there?
So the 1 year status review hearing is actually held 11 months after the care plan is ordered. And at that point, one of three things can happen. Michael can elect to graduate from care. And what this means is that Michael is doing really well, and he agrees that he will work together with the county to develop a graduation plan. The goal of the graduation plan would be to put forth those services that he will continue to engage in even after he graduates from care. The other thing that could happen is that Michael voluntarily elects to stay in care. And the court has to permit this extension, and the extension can only be up to 1 additional year. But a court may agree to that, and Michael may want that because he wants to extend the care services that he's receiving. He feels that he's received better access to those services. He likes the accountability, he likes the structure, and the court agrees that it would be helpful for him to continue in care. The third thing that could happen is the court could order involuntary continuation of care. And this means that the court thinks that care should continue again for up to 1 additional year. And a court may do this because, for instance, Michael just started to engage in services towards the end of the initial year. It appears that he would benefit from additional stay in care and the structure and the accountability that it provides because he's just started on the right pathway. And again, this extension may only be for 1 additional year.
And Leela, you mentioned some of the components of the graduation plan, but let's take a look at that a little bit more. What would the graduation plan include?
So the graduation plan should include the strategies for the support that the respondent needs to successfully transition out of care. It could include a psychiatric advance directive, which would be a document that would allow for individuals in the future to know and understand Michael's preferences. This is something that the respondent can do. It's not required to do, but if he believes the psychiatric advance directive would be helpful, he can have that included in his graduation plan. The graduation plan should not add additional responsibilities or requirements on governmental agencies, and it's not enforceable by a court. So it really is a kind of a a plan and a documentation that would allow the parties to understand how Michael will most successfully transfer out of care and hopefully continue being engaged in services, connected with services, and working towards stability and recovery.
Thanks, Leila. So, we've just walked Michael through from the beginning of the process through his graduation. But let's say along the path, Michael decides not to participate. This is a voluntary court program. What are the implications of Michael's non-participation? So, Leila, describe to us what are the implications if Michael decides not to participate or has declined services in his care agreement or care plan?
So if at any time in the care proceedings, the court feels that the respondent is not participating in the care process or is not adhering to their care agreement or to their care plan, the court may terminate the respondent's participation in care, and the case would be dismissed. The court shouldn't be considering non-adherence to a medication order for reasons of terminating or dismissing the case. If it is really important to remember that, well, the care plan is a court order, this is not a criminal court, and this order does not carry the same penalties that other court orders may. What this means is there are limits on what can happen to Michael if he does not want to participate. There's no criminal consequences. There's no penalties for contempt of court. He will not be subject to any further follow-up as you might with other court orders. But there are some consequences that you should be aware of. Well, there are no penalties to the respondent who doesn't complete their care agreement or care plan. Failure to comply with the care plan will be considered by a court in an LPS proceeding, which is a 5150 or 5250 conservatorship, if one is held within 6 months of the termination of the care plan. So it is not an automatic trigger to a conservatorship, and the proceeding would have to be initiated separate and apart from care. But if a conservatorship proceeding is held within 6 months of the termination of the care plan, a respondent's failure to complete the care plan will be considered by the court in that conservatorship proceeding. And it will be used by the court as a presumption that the respondent needs additional intervention beyond the services and supports that were provided in the care plan. Again, non-adherence to a medication order does not trigger this presumption. And it's very important to note the termination of a care plan does not automatically trigger LPS proceedings. That is not a consequence of failing to comply with a care plan.
Thank you, Leila. And, even if Michael does participate, there are ways that care teams can continue to offer support. So they can continue those outreach and engagement efforts, continuing to build trust and encouraging voluntary participation. And there might be an opportunity to, when he's ready and interested in care. They can also connect him with other programs. So if eligible, he could be referred to other programs like AOT to help provide that wraparound support. They can continue offering services, offer case management, therapy, medication management, housing, and peer support to, again, continue pursuing paths towards therapeutic engagement, building rapport, and meeting Michael where he's at. And then also they can offer to provide family and caregiver support. If we think about Michael's parents, Sarah initially identified as his volunteer supporter, trying to help Sarah understand her role, help her understand coping mechanisms, maybe participate in a family psychoeducation training to help her understand how to engage with Michael, how to communicate, and provide maybe some caregiver support for her as she's continuing to care about Michael and try to engage him in services. So just a few ways that care teams can continue offering support even when an individual may decline services. So now the last thing we wanted to address in this training is about that county responsibility. Leila, you mentioned earlier, it's not just about checking in with Michael and holding him accountable to the services that he's participating in. But this process is really about ensuring county responsibility for providing those services. Talk to us about what that county responsibility is and how CARE helps with that.
So, well, as we've discussed, care is a legal process and there are court hearings. Care really is about the county and the court working together to support the respondent. And to that goal, the care statutes provides provisions that allow the court to hold the county responsible and accountable should the county not provide the services and supports that they either agreed to in a care agreement or they were ordered to provide in a care plan. So the court has the ability to assure that Michael is actually offered the services that he agreed to or that were ordered. And if the county or the other agencies do not provide those services, there are ways that the court can enforce the provision of those services.
Thank you, Leela. So, let's go ahead and look and reflect on the overall process again. So, we've just walked through each step of this process. So I want you to reflect on the different phases that we've walked through. So from the referral and the petition to engagement of the individual to that court process and connection to services, and then that ongoing service delivery period, and consider what questions you may have, what clarifications are needed. You can reach out with any questions you have to the info@careact.org email address. You can also submit TA requests on our website, and those are linked in the training materials for you to consider. So let's take a look at the learning objectives today. We've talked through a lot, but the goal is that by the end of this session, you would have had an increased ability to distinguish those key roles in the care process and know an overall view of what those different roles entail and how they can help support Michael as he is connected to services. And then the goal was that you were better able to describe this overall care process, including that referral and petition stage, engagement, court process, and that service delivery period. Let's take a look at some next steps. So visit careact.org for different resources. We have recordings of past trainings. You can also submit those TA questions. And also you can complete that form if you want to get communication updates on available trainings, resources, TA questions, etc. We wanted to point out some resources to you if you're new to CARE. Take a look at that video you see linked here that will give you an overview of the CARE Resource Center. We have trainings and resource libraries, specific toolkits for volunteer supporters, family members. We mentioned that resources for petitioners landing page, a separate section for those with data collection and reporting responsibilities at County BH, a county directory, and then a lot of FAQs. So you can search those FAQs by topic and really drill down into some of the specifics with CARE. Let's take a look at ways you can connect with us. So again, we mentioned a listserv. You could go to our website, submit those TA requests. There's a specific TA request for data. If you're responsible for submitting data and data collection and reporting responsibilities, you can submit there. Also, there's a stakeholder feedback form if you want to give overall feedback to CARE. And again, there is no wrong door, so you can send any email to that info@careact.org and we can get back to you. So again, if you have any questions, please visit our website or email us at that email address. There really is no wrong door. So thank you, Leela, and thanks for joining, and please let us know if you have any questions.
Thank you, Patricia.